what is the relationship and what are the differences between administrative law and constitutional law. Administrative law and constitutional law are closely interconnected branches of public law. Since the Constitution is the supreme rulebook of the country, constitutional law provides the foundation for all the other laws in the country. Constitutional law defines the structure, the powers and the limits of the three branches of the government. It also covers the rights, liberties and the duties of individuals. Administrative law focuses on the day-to-day functioning of the executive branch and the agencies under the control of the executive branch. So, administrative law derives its legitimacy and a number of its principles largely from the Constitution, and administrative law operates within the boundaries of constitutional law. For example, constitutional law says that citizens have a set of fundamental rights which cannot be violated. Then administrative law ensures that all the actions of the executive are within the boundaries set by the constitutional law. This table explains the relationship between administrative law and constitutional law. In terms of legal hierarchy, constitutional law is the supreme law and administrative law operates under the framework of constitutional law. Administrative law gains legitimacy from the Constitution's grant of power to the executive and the legislature. If the Constitution specifically prohibits something, then any administrative law that contradicts this will be void and illegal. Constitutional principles like the rule of law, separation of powers and fundamental rights guide and limit administrative actions. Constitutional courts review administrative actions and administrative law to ensure that they comply with constitutional norms, providing a check and balance. This concept of judicial oversight over administrative law is provided by the Constitution. In administrative law, we cover the concept of delegated legislation, which are laws like rules, regulations and orders, which are made by the executive using the power that is delegated by the legislature. Here, it is the Constitution which implicitly allows for the delegation of legislative powers to the executive. While constitutional law defines fundamental rights, administrative law provides the mechanisms and the procedures that operationalize and protect those rights. The Constitution shapes constitutional law, and constitutional law shapes the evolution of administrative law. As interpretations of constitutional provisions change and evolve, so do administrative processes and safeguards. For example, when Article 370 was active, constitutional law provided the interpretation of that article, and that interpretation was used by administrative law. When Article 370 was abrogated, this reshaped constitutional law, and these new changes in constitutional law were then followed by changes in administrative law. This table covers the differences between administrative law and constitutional law. In terms of scope, constitutional law has a much broader scope because not only does it provide a framework for the structure of the state and its institutions, it also covers the fundamental rights and freedoms of the citizens. Administrative law has a narrower scope because it specifically deals with the functioning, the powers and the procedures of administrative agencies and the executive. Constitutional law draws its authority from the Constitution. Administrative law draws its authority from constitutional law and also from statutes made by the legislature and any subordinate legislation. Constitutional law works at a higher level and focuses on the distribution of sovereign powers to the three branches of the government, on the organization of government, and on fundamental rights and freedoms. Administrative law focuses on how the executive implements and administers the law and how it uses its discretionary powers. When constitutional law is subjected to judicial review, it is to confirm that the interpretation is in accordance to the Constitution and its principles. When administrative law is subjected to judicial review, it is to confirm that the administrative actions and procedures are in accordance to constitutional law and in accordance to the statutes that give power to administrative law. Constitutional law is relatively more stable and long-term because it changes only when the Constitution changes or the interpretation of the Constitution changes. Administrative law is more flexible and dynamic. It can change and it does change and adapt to changes in the social, economic, political and technological environment. However, any changes in administrative law have to be within the limits of constitutional law. And finally, constitutional law directly enumerates and safeguards the fundamental rights and freedoms guaranteed by the Constitution. Administrative law is more procedural because it ensures that the administrative authorities do not infringe on these fundamental rights and freedoms.